Golden from Memphis, and I'll be presiding this afternoon. I want to welcome you to the afternoon session of the Court of Appeals. Joining me on the panel today are Judge Armstrong from Memphis and Judge McGee from Savannah. We have very few rules here, but I wanted to alert you to the fact. I think Dr. Clark, you'll be representing yourself as the appellant, and you're entitled to 5 minutes, up to 5 minutes of rebuttal if you would like that. And you can let us know after you've identified yourself when the case is called to the docket. And of course, as appellee, you get 15 minutes. So, Mr. Hivner, if you please call the docket.
Julie Clark versus Jeffrey Givens et al.
Dr. Clark, you ready?
I am, sir.
Are you? Please identify yourself and let us know if you'd like to reserve any rebuttal time.
My name is Dr. Julie Clark, and I'm going to reserve 1 minute of rebuttal time.
All right, 1 minute. You may begin.
Well, let me say good afternoon to begin with. I have struggled with what to cram into this 15 minutes, so I'm going to basically give a review of the intentional misrepresentation that I encountered in this case. Judge Lawrence Wallace presided over the trial case last May 7th of 2019. And despite Judge Wallace's characterization that this case was difficult beyond what he had even anticipated, I believe the case can be boiled down to one statement that was made on behalf of Jeff Givens, the defendant. When I asked Mr. Givens, did he not think that I had a right to know that he was disabled before I hired him? His response to me was, well, ma'am, if I'd have told you, you wouldn't have hired me. That statement smacks of intentional misrepresentation. When I met Mr. Givens, I had no idea that he was disabled. He did not look disabled. I only learned of his disabilities when he started using those disabilities as excuses as to why he was not showing up to work at my vacated home in Kingston Springs that I was fixing up to sell. When he started speaking to me about those disabilities after the fact of our contract, he went into great detail how he had been injured in 2011, had broken his left arm, but he explained that most of his disability had come from what he considered a botched synovial nerve block in his neck. And he said he had excruciating pain from his hand up into his shoulder and neck that was unrelenting. He said he had debilitating headaches several times a week. He also said that he had trouble seeing out of his left eye, which he used as an excuse to explain why the paint line going along the junction of the ceiling and wall along my stairwell was completely wobbly and crooked. When I learned of Mr. Givens, it was through my daughter, who was a special education teacher at Harpeth Middle School in Kingston Springs. Her classroom happened to be directly next to the daycare, which was run by Mr. Givens' wife, Wanda Givens. My daughter would spend lunchtime with my grandson, and she noticed Mr. Givens working and doing various carpentry type things at the daycare. She said, well, maybe, Mr. Givens might be able to do some work for you, because she knew how much difficulty I was having finding good workers in a housing boom. I mean, I couldn't get even the qualified workers to return my phone calls. So in January of 2016, when I went to pick up my grandson, I asked Mrs. Givens, does your husband do work for individuals other than the Cheatham County School District? And instead of telling me what she told Liberty Mutual a mere 3.5 months earlier, I neglected to mention that when Mr. Givens told me about his disabilities, he also told me that he was in the middle of a workers' compensation suit with Liberty Mutual against his employer where he was injured. And so both him and Mrs. Givens gave depositions in that workers' compensation suit. Well, in September of 2015, like I said, 3 months before she told me that Mr. Givens could do anything that I wanted him to do, she told Liberty Mutual that Mr. Givens could only use his left arm as a prop. He had not worked since 2011. He sat around the house, couldn't even mow the lawn, but she told me that he could do anything that I wanted him to do. And she specifically named 4 categories: carpentry, electrical, plumbing, and HVAC. It's clear that Mr. and Mrs. Givens meet the criteria for fraud. Both Mr. and Mrs. Givens made a representation to me as concerned Mr. Givens' physical capabilities, and Mr. Givens went a step further when he told me he was an experienced painter. Secondly, both Mr. and Mrs. Givens knew that these were false statements because they had made statements to the contrary to Liberty Mutual. Thirdly, they used these representations to induce me to hire Mr. Givens. I was so induced, and finally, I suffered damages as a consequence. This simply could have been a he said, she said case if it wasn't for those depositions. When I went to General Sessions, I know nothing about the law before this. I knew nothing, I should say. I didn't know what pro se was. And I had never sued anyone in my life, not since and before, despite the fact that I had a veterinary clinic in Camarillo, California, built from scratch, according to my design, that I've owned 6 homes that I've maintained and improved. I was a sole practitioner in that clinic for 17 years, maintaining it. My father was in construction. I know something about construction, but I've never sued anyone. But when I found out about these depositions, I was shocked. And when Mr. Givens gave his deposition in July of 2014, he went much further than what even Mrs. Givens said. He said that his condition was not improving. It was getting worse every year, that he went on to repeat that he was in pain from his arm.
Dr. Clark, I have a question. Are these depositions in the record?
They are. In the trial court, by the time I went to the circuit court, I was able to get those depositions with a proper certificate of service. Man, I know what a certificate of service is now.
My question, though, is have they been admitted into evidence in this case?
They, oddly enough, I tried to get them and they weren't, they acted like they weren't going to give those to you for some reason, but they are referred.
Listen to my question. Were these depositions admitted into evidence by this judge in this case? Are they part of the record on this appeal?
They are part of the record.
Okay, were they admitted into evidence?
Yes. I mean, that could have been a mistake on my part. I used those documents throughout the entire trial and referred to them constantly.
Well,
but I don't know if
copies of those depositions in this record that we're going to review.
Repeat that, sir.
Are copies of those depositions in the record that we're
They are
going
not. But
Okay.
I refer to them in detail in the record that you do have, the court transcript.
Is there testimony from those depositions
Absolutely.
in the court transcript?
Absolutely. Plentiful.
All right. Go ahead.
Yes. So, being pro se, I may have not entered those in as I probably should have, such that they came to you. I didn't understand why they didn't come to you, but they are in the transcript. So, as I was mentioning, Mr. Givens, in his testimony to Liberty Mutual, said that his condition was only getting worse. He was in constant pain. He had to hold his left arm against his chest at all times. He went on to other things that he had not told me, in addition to the headaches and not being able to see out of his left eye. He said he couldn't tolerate hot and cold. He had skin conditions. He had heart palpitations. It went on and on. And so as a result of that Liberty Mutual workers' compensation case, Mr. Givens was awarded $170,000 in February of 2017. And he was declared 71% permanent partial disability as pertains to his body. So I was baffled when Judge Wallace made his ruling. I feel Judge Wallace erred in not acknowledging the intentional misrepresentation on the part of both Mr. and Mrs. Givens, and the fact that he didn't use the Tennessee Consumer Protection Act when it was warranted. In the Tennessee Protection Act, 47-18-104B, number 7, it states that it is unlawful to represent goods or services as being of one standard, quality, or grade when they are of another. Both Mr. and Mrs. Givens definitely fulfill that violation. It also states in 47-18-109A1 that when someone sustains damages as a result of the previous violation or any violations in Part B, that an individual can take action to recover those damages. And that was my entire case from day one. I have not changed my entire stance all along. On the other hand, Mr. Koppel, the attorney for the defendants, has never once addressed the intentional misrepresentation perpetrated by his clients, never talked about it. He has never once spoken to the fact that Mr. Givens is a sorely inexperienced painter. When Mr. Givens' exact words to me is that I've done lots of painting, I'm a great painter. And what Mr. Koppel bases his entire case upon is portraying me as breaching the contract as a result of custom-built homes versus McNamara, where 4 criteria are listed as a way to lawfully terminate a contract. Mr. Koppel says that Mr. Givens doesn't meet any of those, when in actuality, Mr. Givens meets all of them. He was unable to complete the contract physically. He showed an intent to abandon the contract. He repeatedly did not show up to work. I was busy working at the time, and I would come check on the house, and not anything would have been done from one week to the next. And that's when he started telling me he had all his problems. He also appeared to no longer be bound by the contract. And most importantly, he committed fraud. I don't feel that it's appropriate to even speak of a breach of contract in this case, because there can be no meeting of the minds. There can be no contract when one party has been severely, material information has been severely omitted, willingly and with a forethought. So I am asking this court with all my heart, because this has been a long 4.5 years, to hold Mr. and Mrs. Givens accountable for their violation of the Tennessee Consumer Protection Act 47-18-104B Part 7, to award treble damages because their violation was willful and knowing, as is stated in 47-18-109A3, and to award the attorney's fees and costs for the trial court, as is recommended in 47-18-104E1. And finally, there are no attorney's fees in the appellate case, but to award me the substantial appellate costs, because I had to pay for the transcript and of course the fees to file the appellate case. But those appellate costs are recommended to be offered to a Tennessee Consumer Protection Act individual in Killingsworth versus Ted Russell Ford, Inc. Finally, I want to just quickly read a statement by Justice Warren D. Wolfson. Justice Wolfson says, we still understand hard-won rights can be lost simply by taking them for granted. We are reminded every day that we function in a public place where truth is truth and lies are lies, where people who act must be held accountable, and where the state is held to certain standards. We don't need more laws and higher penalties. We need vigilance. I thank you.
Thank you, ma'am. You'll have your 1 minute left after Mr. Koppel argues.
Thank you, sir.
Mr. Koppel? Your audio's not on.
I apologize. Thank you, Your Honors, and good afternoon. May it please the court, I am George Koppel of Nashville, representing Jeff Givens and Wanda Givens in this case. In this case, the trial court dismissed the suit for breach of contract. And I will refer to my client sometimes as contractor. He's an independent contractor. That's clear. It's not disputed that he was not an employee. It's in the record that Ms. Clark admitted that he was an independent contractor. And I will sometimes refer to her as the owner. So what we have is a small construction contract here. It's verbal. It's for doing a lot of painting and some maintenance and repairs, miscellaneous things to get her house in shape to be put on the market. The contract was reached verbally between the parties in January of 2019. And the reason that the trial court gave for dismissing the, rescinding the contract and dismissing my client's claim, the contractor's claim for breach of contract, was what the trial court called mutual mistake. And what mutual mistake was the trial court pointing to? The trial court said that the parties' failure to arrive at an agreed time of completion was a mutual mistake. Now, I'll come back to the mutual mistake. That's what the trial court ruled. He didn't rule on any of the stuff that Ms. Clark talked about. That was his ruling. And he rescinded the contract and dismissed both parties' claims for breach of contract on the grounds of mutual mistake. And we'll come back to that. Now, a time of completion clause is simply a clause in a construction contract in which the parties agree that the contract will be completed, the work will be completed by a certain date or within a certain number of days or weeks or months. It is not required. It is common for tradesmen and small contractors to talk with homeowners and to agree to do any number of things: painting, carpentry work, plumbing work, electrical work, and they reach a verbal contract. It is not required that you have a time of completion clause. Now, time of the essence clause. A time of the essence clause is a clause in which the parties explicitly agree to the phrase, time is of the essence in this contract. Or in this contract, the parties hereby agree that time shall be of the essence. It has to say essentially that. And the significance of it is that without a time of the essence clause, slow or delayed work, not finishing in time, going past a deadline, is not a material breach of contract. It is not a material breach of contract to violate a time of completion clause unless you have a time of the essence clause. And my authority for that is set forth on pages 14 and 15 of our brief. Madden Phillips Construction Company versus GGAT Development Corporation, a 2009 opinion of the Court of Appeals, and it's a reported decision. That case holds that, quote, a party's failure to complete a construction project within a time for completion does not constitute a material breach absent a provision making time of the essence. And that case cited and relied on a 1998 Court of Appeals opinion, also a reported decision. This is on page 14 of our brief, which was Shepard versus Perkins Builders, holding quote, generally time is not of the essence of a building and construction contract. So what the court did was the court erroneously, and this is purely a question of law.
Mr. Koppel, let me ask you this.
Yes, Your Honor.
Does that mean that it could take an indefinite period of time to complete the contract? Is there any limit on the time that your client would have had to complete the contract?
She would have remedies, Your Honor, but she wouldn't have the remedy of terminating the contract. And that is correct. And of course, that's the reason that lawyers would recommend that they enter into written contracts. But that is the law. And I have not been able to find any discussion that said, well, you know, if it got to be, as you say, 4 months, you know, it's supposed to be 2 weeks and it's now 4 months, or it's supposed to be 2 months and it's now a year. I haven't found any cases that, you know, talk to that kind of extreme situation. But in this case, it's admitted that the parties did not agree. They did not reach agreement. So not only did they not have a time of the essence clause, they didn't have a time of completion clause, not one that they had agreed to. Now,
well, let me ask you this.
Yes, Your Honor.
Was your client aware that Dr. Clark that the purpose for which he was being hired was to get this house ready to be put on the market?
Yes. And what the record shows, Your Honor, is that in their discussions, she testified. Again, there's no proof of this. There's nothing in writing. She testified that she told him she wanted it done in 2 weeks. He testified that he estimated 4 to 6 weeks, but he did not guarantee that it would be completed within 4 to 6 weeks. And the judge made no finding that either one of them was more credible than the other with regard to that or any other issue. So we have a situation in which there is no time of completion clause, and certainly no time of the essence clause. And I don't want to take up too much time on this, but, you know, if Your Honors will think about it, I'll bet that none of us have ever seen in our entire lives a verbal contract between two non-lawyers where the homeowner is not a lawyer and the contractor is not a lawyer. They're just normal homeowner and tradesperson acting as an independent contractor, in which either one of them even came close to saying, oh, by the way, can we agree that time is of the essence in this contract? That's just never happened. If you're ever going to have a time of the essence clause, it's going to be in a written contract. And this was clearly, all that happened is she told him what she wanted. He did some calculating and came back in 15 minutes and said, I can do it for this amount. And she said, okay, when can you start? That was the contract.
Did they reach an agreement about the contract amount?
Yes. It's 11,500 and I'm sorry. 11,000. And she paid 4,500, Your Honor, and that left our total claim at 7,075. And I apologize, I have to add that in my head. That'd be 11,575 was the contract amount.
Did Dr. Clark agree that that was a contract amount?
Yes.
Or did she testify that it was a lower amount?
Here's what happened. Her testimony was that there were certain items that Mr. Givens testified were part of the contract that she said, I didn't agree to that. I talked with you about it. I told you about it. I told you I'd probably want you to do it, but I wanted to hold off until I saw how you did on the painting part of the contract. So her position at trial was not that the 11,575 is an erroneous number, but rather that only about 9,000 of it was actually contracted for, and the rest was to be contracted for. So that's the full answer to your question. But see, it's important to remember, Your Honor, and all of Your Honors, the judge made no findings on any of these things. He made no findings or conclusions as to anything that Ms. Clark said in her presentation. He made no findings as to the scope of the contract. What he found was that by not agreeing to a clause for time of completion, that they had made a mutual mistake. So let me go on with the rest of that, so I don't run out of time.
Why would that necessarily be a mutual mistake? In other words, if you have an oral contract like that, why wouldn't you make a determination as to whether or not that it was a reasonable time? What would be a reasonable time for the contract to be completed?
Exactly, Your Honor. But you see, let me tell you what the law says a mutual mistake means. I'm going to give you two examples. These are from Sikora versus Vanderplug, which is a reported case from 2006. And here's a good example. Let's say there's a house that's going to be built, and I'm going to try to speed up here so I don't run out of time. A house that's going to be built up in the mountains, and both parties assume that there is a road that leads up to it, not necessarily a 4-lane highway, but some sort of access road to where they can get the construction equipment up there, the earth moving equipment, the heavy equipment. And then they enter into a contract on that assumption. They both assumed that it was accessible by road. And then they find out that there's not even a road up there. Well, that's a mutual mistake of fact. They both assumed a fact that it turned out not to be true. So the court can rescind or reform the contract because of their mutual mistake. Now, in the Sikora case, Your Honor, it was...
Well, how is that analogous to this case?
It's not.
Where there's no issue about accessibility. There's no issue.
Right.
I mean, in other words, we're talking here about whether somebody shows up for work and does the job that they've been asked to do and been contracted with to do, whether they do it in a workmanlike manner on a day-to-day basis. In other words, and they're performing the contract in a reasonable manner. I'm having a little concern here about the basis on which this came down.
Yeah, well, Your Honor, what we say is that the example I gave you is a classic example of an actual mutual mistake.
What's the actual mutual mistake here?
There isn't one. It's error. It was error. See, Your Honor, we're cross-appealing. Your Honor, let me apologize to you. It seems like I raised my voice at you, and I didn't mean to. So
no, I didn't take it. I didn't take it.
Okay, thank you, Your Honor. But we are cross-appealing. We're not upholding the judge's decision at all. This is the judge committed a clear legal error by trying to rescind the contract and dismiss our motion, our breach of contract claim on the grounds of mutual mistake. There was no mutual mistake here. A mutual mistake is where they both thought there was a road and there wasn't a road. What he's saying is, I think it would have been better if you had agreed to a time of completion. That's not a mutual mistake because a time of completion clause is not required. Now,
is it a breach of contract to fail to show up for work on a timely and regular basis?
No, Your Honor. That an independent contractor can choose when and how he does his work. You can't say, now look, we're starting at 9 o'clock tomorrow morning. If you're not here, I'm firing you. A house painter can show up anytime he wants, as long as he gets the work done. And he was getting the work done when she terminated the contract. But remember, I'm not asking you all, you members of the Court of Appeals, to rule that he is entitled to damages for breach of contract. That's going to be done on remand. What I'm asking you to rule is that it was legal error to rescind this contract and dismiss our claim for breach of contract on the grounds of mutual mistake, because that's not a mutual mistake under the law. Now, I'm just about out of time, but
your argument is that he could not show up for work for a week or two and get nothing done, and that would not constitute a breach of what they agreed to.
Well, Your Honor, there's nothing in the record that shows that that happened. But yes, an independent contractor sets his own hours. It's the way it works. He didn't not show up for a week or two, but that's not before the court. It's not before the court. You see, the judge's ruling did not make any findings like that. May I have 45 seconds to wrap up? Yes, Your Honor. No,
No.
go ahead.
No, I'm sorry, that your time's up.
May I have,
No, sir.
okay, I
Time.
apologize, Your Honor.
Time's up.
Thank you both. Thank you all three for your kind consideration.
Dr. Clark, you have 1 minute for rebuttal. Your audio's not on.
To begin with, I contend there can be no contract when there was intentional misrepresentation, but I would behoove you to look closely at the brief that I submitted. It is in the record that both Mr. Givens and I agree how long he was on the job. He was on the job 30 days, and we agree how much work he got done. I had a 3,000 square foot house, and he was supposed to paint the inside of the garage walls also. He never got past doing one coat on the loft upstairs and the sloppy job he did going down my stairwell. And he also was supposed to strip and prime my kitchen cabinets and bathroom cabinets. He did it incorrectly to where it all had to be redone. He used a satin finish that had to be replaced.
I mean, Dr. Clark, is there a transcript of the testimony in this trial?
Absolutely. I have all kinds of references that will help you immensely.
But in other words, did you have a court reporter transcribe the testimony at trial?
Yes, I paid $1,600 for it, sir.
All right, thank you. All right, thank you very much.
Thank you,
Thank
sir.
you, Your Honor.
We'll deliberate and give you our opinion in writing as soon as it's completed. Thank you so much.
Thank you very much, Your Honor. All three of you.
All righty.
This honorable court is now in recess until 2 p.m.
And we're out.
Counsel, you can